All right, thank you for sharing those updates. The Supreme Court has refused to stay the Waqf Amendment Act provision requiring registration of Waqf by the user, but has paused the clause that states a person must be a practitioner of Islam for 5 years to create a Waqf until the state governments frame relevant rules, as the Supreme Court flagged that some of them will lead to arbitrary exercise of power. The bench of Chief Justice of India B.R. Gawai and Justice A.G. Masi said that it found no case was made out to stay the whole statute, but some sections need some protection. These provisions have been paused till the petitions challenging the constitutionality of the Act are decided. The new law had empowered the district collector as the final arbiter in issues related to the Waqf property ownership. The bench also said that not more than 3 non-Muslim members should be included in the Waqf Board and not more than 4 in the Central Waqf Council. The court noted that the presumption is always in favor of the constitutionality of the statute, and an intervention must be done only in the rarest of rare cases. In fact, let's quickly take a look at the provisions that are being stayed and which are the ones that have not been stayed by the Supreme Court in its interim order today. I'm going to quickly take you through what is it that the Supreme Court has accepted is going to be used as a mandatory guideline under the Waqf Act, the amendment that was made earlier in 2025 this year, and what is it that raises concern for the Supreme Court to the amendment then being rectified, changed, modified, and then brought back into the court. Let's take a look at the provisions that have been stayed by the Supreme Court. Number 1, district collector as final arbiter in Waqf property ownership. That's a question that has been raised in terms of whether the validity of an arbiter, the district collector as the arbiter, should be accepted under the Amendment Act. The second stay that has been done by the Supreme Court is the requirement that a person must have practiced Islam for 5 years before creating Waqf. Amendment number 3 that was made in the Act that has been stayed by the Supreme Court says that more than 3 non-Muslim members should not be included in Waqf Board. In fact, there has been another change that the Supreme Court has asked for the government to make, is that the government's power to de-recognize Waqf land while dispute is pending is null and void. In fact, let's take a look at yet another amendment. In fact, the separation of trusts from Waqf, which are key provisions that have not been put on the stay order of the Supreme Court. Number 1, trusts created by Muslims under any law will no longer be treated as Waqf. Individuals retain full control over their trusts and management of assets. In fact, let's take a look at the other observations that have been made by the Supreme Court in its order. Technology will be leveraged to make Waqf management more scientific, efficient and transparent. Improved accountability and streamlined processes are key goals. So in terms of the provisions that have not been stayed by the Supreme Court, these are the one that are included. A new portal will automate the complete life cycle of the Waqf properties, covering registration, accounts, audits, contributions and legislation. So these are the acceptable inclusions in the Amendment Act that the Supreme Court has taken note of, and amongst those there is also the existing Waqf by user properties registered with Waqf Boards remains intact until disputed. According to WAMSI, there are 4.02 lakh Waqf by user properties out of the 8.72 lakh total Waqf properties. So it's half of the Waqf properties are taken control of by those people who have the property under the clause of Waqf. In fact, Let's take a look at inheritance before any property is dedicated to Waqf. Special provisions are included for widows, divorced women and orphans, ensuring their rights are also safeguarded. All right, so these are the provisions that are acceptable to the Supreme Court. Limitation on Act will now apply to Waqf property claims, reducing prolonged litigation. Mutawalis must recognize property details on portal within 6 months of registration, and Section 40 is removed, preventing Waqf boards from arbitrarily declaring properties as Waqf. So these are a number of these amendments that were made in the Waqf Act, and these are all acceptable to the Supreme Court, barring two of those concerns that have been raised, and which is going to force the government to further deliberate on the modifications and changes that will then have to be made. The Waqf institutions' mandatory contribution to Waqf boards reduced from 7% to 5%. And Waqf institutions earning of over 1 lakh rupees must undergo audits by state appointed auditors. All right, so those are the important aspects of the interim order that was heard in the court today, that was pronounced by the court bench that was led by the Chief Justice of India himself. I am going to hold a discussion on this very complex matter that has been arbitrated by the Supreme Court bench today. Joining me on the telecast is Justice A.N. Mittal. He is a former Allahabad High Court judge. Justice Mittal, let's hear it from you with regards to these concerns that have been raised by the Supreme Court bench, particularly about the issue of how it is going to be determined if an individual is a practicing Muslim. The time that has been bound for 5 years, how is it going to be identified, accepted and recognized as an individual who is practicing Islam?
Basically, this judgment of the Honorable Supreme Court is a very good judgment, and the restriction which was put by the amendment has been done away. Now, the impact of this is that any person who may be practicing Islam maybe for 1 year or 2 years, he can also donate his property to the Waqf or create a Waqf. Basically, this Amendment Act was in force on 5th of April when the President of India gave its assent. The Supreme Court has declined to stay all of the provisions of the Amendment Act and has only stayed 2 provisions, one regarding the 5-year limitation and secondly regarding some things mentioned in section 3. Basically, Supreme Court has also said that the compulsory registration of the Waqf was in force since 1923 and not from 2025. So it's a almost 100-year practice and mandate to get any Waqf registered. There was much dispute on the properties which were not registered, and it was said that this property shall belong to the government. Supreme Court has also clarified this position and has said categorically that it cannot be deemed to be a government property unless the executive, after due inquiry, comes to this conclusion.
All right.
So basically, this judgment of the Honorable Supreme Court has welcomed by all the political parties, and it's a good sign for our constitutional democracy that the parliamentary supremacy has been maintained.
Okay. All right, stay on with me. So I'm also being joined by Kailash Vasudev. He's the Senior Advocate, Supreme Court of India. Advocate Vasudev, what do you make of this judgment that has been passed by the Supreme Court? Why is the Supreme Court not in alignment with the government that has made these amendments to the Act?
See, good evening, these amendments have been made with very far-reaching consequences. The provisions of the Act per se, in some areas, where the Supreme Court has found there may be an arbitrary exercise of power, have been stayed. The other areas they have not yet. Take, for example, the power of the designated officer, the power of a Waqf recognition initials. Now, these are areas which will be a matter of final disposal when the appeal is heard. But for the moment, it's a protection which is extended to the individual community members, as also giving the government a chance to relook at the whole situation. We should not go by a judgment of the court at this stage because it's an interim order. Although it's lengthy, it considers all aspects of it. Being an interim order, we will see what happens in the end. But for the moment, it's a protection which is afforded to those who are members of the community or the running of Waqfs and the management thereof. The rights and the other positions which are there in the rights of government have not been dwindled. They're still there. So therefore, let us see how it goes. It's an interim order. And interim orders are always modified at the final stages. The hearings will come. But for the moment, it's an order which, to my mind, is fair to both the government and the community.
Okay. All right. I'm also going to get in Sham Sharif Ryan on the telecast with me. Sham Sharif, another important stay that has been put by the Supreme Court is about the arbitration of the district collector in all Waqf property related matters, talking about how if this responsibility is handed over to the district collector, it violates the separation of ownership, separation of the jurisdiction. The arbitration cannot be done by a third party. How do you view this particular stay that has been put by the Supreme Court?
The arbitration is always done by a neutral party. So if it is imposed there, the rule says that. So the person who would be the arbitrator in this matter would be a neutral person. So if the dispute is between the government and someone else, then the arbitrator will not be the magistrate, will not be the DM. It would be someone else. But otherwise, it's always the third person who is a complete neutral party. That person can only become an arbitrator. So in case there is any kind of a dispute wherein one side says that the arbitrator appointed in the matter is someone who has a little interest in that case, so that matter would be transferred to someone else who would be a neutral party in that case.
Independent arbitrator.
Independent arbitrator.
Yeah,
right.
Yeah, absolutely, absolutely. Ashwini, let's hear it from you. These were also some of the big concerns that had been raised by the petitioners who had put forth their case and arguments in court. Now the Supreme Court also at this point in time observing that yes, these are sensitive matters, and therefore an interim order being passed, stay has been made on 3 of these key issues, talking about the district collectors' powers and position, talking about how there cannot be more than 3 non-Muslims who can be part of the Waqf Board, talking about how it is going to be the onus on the state governments to then make a decision on who a practicing Muslim is, which is in itself a very complicated and complex decision to make. How do you think is it going to be the task that is to be performed by the Supreme Court, by the state governments? How are they going to be able to make a decision regarding who a practicing Muslim is?
Megha, the answer is very simple. One who practices Islam is considered to be Muslim. They have their essential religious practices and that they follow, and then they possess the faith of Islam and they follow the Islam. Now, the 5 years period has been taken over only for the time period, saying that it shall stand state until the rules are framed by the state government for providing a mechanism for determining the question as to whether a person has been practicing Islam for at least 5 years or not. So there is a mechanism which has to be framed. Point 2, as you rightly said, that 3 issues were framed. One, challenge to section 3, subsection R of the Amendment Waqf Act, which says that de-recognize work by user prospectively. What was very clear? Prospectively. Now to the challenge to the special provision for government properties under section 3C of the Amendment Waqf Act, and challenge to the composition of Central Waqf Council and State Waqf Board under section 9 and 14 of the Act. So there 3 and 4 non-Muslim members have been included, and that is very categorically this judgment have said. The sole idea for bringing this 2025 Amendment Act was to improve governance and administration of Waqf properties by introducing greater inclusivity in Waqf bodies. And that is why there was a need that the Waqf has started claiming that it has become owner of the largest chunk of land of the government, Bharat Sarkar, that except the army and this railway, they were having the third, they were claiming ownership over the third largest land of the country. So there was a need to regulate that. Number 3, very important point, as Constitution says, and as we often talk, that the country is secular, but this law was completely a religious law supporting one particular community. We live in some secular country, then law should be the same for the Jainism, for the Sikhs, for the Christians, for the Judaisms, for the Parsis, but there was no such law. Fourth and important point is there are 3 kinds of judiciaries, and my respected senior Mr. Kailash Vasudev will agree that the district judiciary, state judiciary, and union judiciary. If you see, before bringing this amendment, the tribunal's decision under the Waqf Act was final and binding. None of the courts had a power to adjudicate. Now the appellate court, means the high court, after the tribunal's power, have a right to adjudicate this issue. So we think that when we live in a rule of law country where the law are framed, 3 judiciaries are already there: union judiciary, state judiciary, district judiciary. So if any property dispute is there, it is adjudicated by the court of law. There is no problem at all. As you rightly said, Megha, that the Limitation Act, there was Limitation Act applicability even in this case, which is normally followed in the property cases. So I think that this order, which has been passed by the Honorable Supreme Court, by certain modifications of the Act, is welcoming. Final decision has yet to come, but the disputes and property claims, administrative and role of the judicial bodies, and the Waqf tribunals and the appeal process, all those things have been streamlined in the Act, and which has been considered by the Honorable Supreme Court. And as far as one important point, section 40 of the earlier Act, which was a unique provision which was made authorizing the Waqf Boards to make an inquiry, to whom, Megha, very categorically I am saying, authorizing the Waqf Boards to make an inquiry in respect of any land to find out as to whether the property is a Waqf property or not. यानी वही डिसाइड करेंगे, भाई आज तो ये मेरी प्रॉपर्टी हो गई, तो उस दिन से उनकी प्रॉपर्टी हो जाएगी. That provision has been taken. That was very draconian provision. Okay. Means reason to believe by the board. And so far as the designated officers we are talking about, designated officers, yes, that provision Supreme Court found that yes, collector suo moto, one-sided cannot take over any decision. Collector, because the role of the judicial body and quasi-judicial body is already defined, so collector, executive cannot perform the role of the judiciary. So that is the designated officers.
Yeah, absolutely. Absolutely.
Yes.
So, Justice Mittal, with regards to all these reservations that have been expressed by the Supreme Court, and therefore a stay that has been put on these 3 very contentious inclusions in the amendments that have been made in the law, in the Waqf Properties Act, why do you think these inclusions were made in the first place? These amendments were made in the first place, keeping in mind that they are contentious and issues were anyway going to be raised, concerns were going to be raised by the parties, by the stakeholders involved. Okay, Kailash Vasudev, would you like to take that question?
See, the question is this. The Waqf properties, let's put it to you differently. There is the Endowment Act, the Hindu Endowment Act. That also provides for the taking over of certain institutions which are religious in nature. It is very effectively used for management of the Hindu shrines in the south. Now, Acts have been passed for taking over shrines of the communities which are wealthy shrines. Take the Waqf Board, been taken over. The Tirumalai Board. So you see, religious sanctity is given to the individual religions, yes, but management of properties has got to be controlled someplace to prevent an abuse thereof. The Waqf Act is now seeking to impose a restriction on the arbitrary exercise of power by the Waqf Boards. It is not unknown in our system that when a religious body comes in to control its own affairs, we invariably land up with difficult times. Handing over of properties, management, distribution of the assets, distribution of the incomes, all sorts of things come in. So it became necessary to regulate what is a Waqf, how to manage it a little bit, and a certain amount of supervision by the government. The question today is, has this amendment totally secluded the rights of the community from management of its property? No, it has not. It is seeking to regulate it. There are some provisions which the Supreme Court has not stayed, and there are some provisions which the court has stayed in the larger interest of the community to maintain a balance in the implementation of the Act at an interim stage.
Okay.
Therefore, to say anything to the contrary, I think is a bit premature on our parts. Leave it open to the court. Let a final decision be taken. In the interregnums, the court has made the Act workable without causing rancor on both sides. That is my view in the matter.
Shams Sharif, quickly a comment from you before I wrap this up. Do you think this interim order is now acceptable and digestible to all parties, particularly the petitioners who have been raising their concerns and putting forth their arguments in court against these amendments that have been made?
No, I think that since the interim order has been passed by Honorable Supreme Court, and I believe that everyone who have approached Supreme Court, they know that how good the Supreme Court is. They totally bound to what the Honorable Court has said. So I'm sure they would believe that whatever order has been passed, they would be happy with it. And of course, once the implementation starts and once any kind of a dispute actually comes in, that's when they would really make a suggestion over here that whether that clause section also should be stayed or not. So as if for now, they might be happy that a few points, major points have been stayed. But let's see how things goes. As Mr. Kailasher has said, that it is too early to speak about it. Let the Supreme Court deliver a judgment in this matter and then make a statement. After that, it would be right for all of us to yes, sir.
Okay.
There's another issue I just want to point out. There's an interim order. If there's a working difficulty or an issue which one might feel angst or might feel difficult about, you can always go to the court and ask for a clarification or an amendment.
Yes.
See, that power is with the court. It has not been taken away from anybody. And it is always open to a aggrieved party to seek a clarification, modification, whatever you want, for the purpose in the longer interest of the working of the Act.
Yes.
Okay. All right. I thank all of you for sharing your inputs and explaining to us in detail what the Amendment Act entails, and more importantly, what the interim order of the Supreme Court bench was today, and how it justifies the stay that it has put on these three contentious inclusions, the amendments that were made by the government. I thank all of you for joining me on the telecast, and thanks for watching NewsX.